ประเทศไทยก็ได้ถูกเป็นหนึ่งใน75ประเทศที่ US Department of State ระงับชั่วคราวนะคะระงับในการออกวีซ่าถาวร
สวัสดีค่ะ
สวัสดีค่ะพี่เกศสวัสดีค่ะทุกคน
สวัสดีค่ะก็วันนี้หลายๆคนคงจะติดตามข่าว ติดตามข่าวทาง The Government ตลอดเนาะว่าตอนนี้เขาเปลี่ยนนโยบายแบบนี้และหลายคนนะคะลูกค้าหลายๆคนก็ติดตามแล้วก็สอบถามมาว่ามันจะเอฟเฟกต์พวกเราหรือเปล่ามันจะมีผลกระทบอะไรกับพวกเราหรือเปล่านะคะ
ก็รีแคปนิดนึงจากที่พี่เกดเล่าเนาะเมื่อวันที่21มกราคมที่ผ่านมาประเทศไทยก็ได้ถูกเป็นหนึ่งใน75ประเทศที่ทาง US Department of State ได้ขอระงับชั่วคราวนะคะระงับในการออกวีซ่าถาวร
ค่ะ
เนื่องจากที่บอกว่าจากสถิติเรามีปริมาณหรือว่าอัตราการขอใช้สวัสดิการของสังคมค่อนข้างที่จะสูงเราก็เลยถูกเป็นหนึ่งใน75ประเทศนั้นแต่ว่าวันนี้เราก็ได้เชิญทางทนายคุณพอลรูบี้ใช่ไหมคะที่จะได้เข้ามาชี้แจงว่ามีผลกระทบอะไรยังไงกับ EB-3 Unscrewed ที่สำหรับท่านที่สมัครเข้ามาแล้วหรือว่าคนที่กำลังตัดสินใจว่ากำลังจะสมัครเข้ามา
แล้วบางคนถึงขนาดถามว่าEB-3 วีซ่าจะถูกแคนเซิลไหมนะคะก็เดี๋ยววันนี้เรามาฟังตรงๆเลยกับทางทนายนะคะเพราะว่าท่านเป็นผู้รู้ทุกอย่างเกี่ยวกับตรงนี้อยู่แล้วนะคะแล้วก็ทำเกี่ยวกับ EB-3 วีซ่านะคะแล้วก็ทำเคสให้กับพวกเราทุกคนด้วยนะคะ
เดี๋ยวก็ผู้เชี่ยวชาญเฉพาะด้านนะคะที่มีดีกรีทางด้านกฎหมายแล้วก็ดำเนินการไฟล์ฟอร์มต่างๆให้กับผู้สมัครของพวกเราขอเชิญคุณพอล Hello, good morning, Paul.
Hi, everyone. How are you?
Good, very good. So thank you so much to join us today. And yeah, many people ask about the new rule, the new policy from the government, and then they worry, if it will affect to EB-3 visa that we work on that, So can you explain a little bit about that?
Sure.
Okay. Before you start, could you please introduce yourself one more time for some people might have never listened before?
Hi, everyone. How are you? My name is Paul Ruby. I'm a business immigration lawyer. I live in Nashville, Tennessee, but the immigration laws of the U.S. are set by the national government, so they're the same everywhere. We work with businesses all around the country, and and of course, people in the U.S. and all around the world to manage the legal processes within EB-3 and lots of other things. I've been doing this almost 20 years. It's going to be 19 years in May. Our office is fairly big at this point. We manage a lot of these cases. We have lots of experience, I think a pretty good track record, in this program and in others. There are, I think, a lot of questions for us to go through. The early ones are going to be all about the restrictions on immigrant visas put in place by, the current administration, the government to the U.S. Mm-hmm. And we'll talk about what those mean, what is happening now, and also what could happen in the future. I think I'm going to take a few topics on this together and just go through everything. So a few months ago, there was a news story that said the Department of State is stopping issuing what they call immigrant visas, which are visas that result in a green card. That could be through the family system. It could be through the business immigration. Here, this time of year. It could be through the family immigration system. It could be through the business immigration system. It could be through something called the diversity visa lottery, and so on. And they said the restriction applied to people from 75 countries. And that was just in the news. then, and that was overnight, one night, and everybody got very worried the next morning. That night, the Department of State put out their own notice, and they said, we are restricting it. It is based on the fact we think people from these 75 countries arrive to the US and they too often require assistance from the government, financial assistance. And to me, obviously, any restrictions on visa is bad, right? Like, we do not like them. We do not like anything that makes this process harder.
No.
We do not like anything that makes this process longer. But, we have a saying here, and I don't have one, but this is my water. We say, is the glass half full, or is it half empty? And you look at things in a positive way, or do you look at the same facts in a negative and sadder way? And I look at this as the glass is half full. I try to do that in life, but also in this case, it's very true. Because when they say the restriction is based on economic reasons, it means there's going to have to be a way for us to get around the restriction. And employment cases, that's usually quite easy, right? Because people have a job offer and they can show, look, I have a job offer. I'm going to be working at any of these employers and earning a certain amount of money. And usually the employers are also happy to discuss possibilities even with the spouse. And then they can say, look, together we will be earning, way more than the limit the US government usually looks at for these things. And so, the restriction is bad. We don't like it. But even as it stands today, even if it holds up and is the case and is the rule for the next few years, there's going to have to be a way for us to overcome it. And so I think that's one of the critical points here. The other thing too is that this is already being challenged in court, that says, they designed the system, and the family immigration system has something in it where a family member has to agree to cover costs. Like the US family member, the US citizen or green card holder petitioning for their son or their spouse or whatever it may be, already has the financial, kind of backstopping in there. And the lawsuits say, and the employment people have an offer of employment, and, if anything, this maybe should only apply to diversity visa. But I think we have a very strong case there, and I think there's a good chance this restriction will not continue, at least for business immigration cases. But like I said, even if it does, we still have the fact we will be able to, prove that they are incorrect, or maybe it's our responsibility to show we're above a certain amount. And so that's what we're going to do. And the job offer usually is enough to do that. So I look at this as a frustrating sort of thing. There's no other way to look at it. But we also have to, think of how will it impact us? How will it impact our cases? And even if it stands, we're going to be able, in many cases, to get around it. In most cases, or all perhaps. And then, like we said, there's a good chance that it's not going to stand up, at least for business immigration cases. And I would compare this, to something that would have worried me, right? Like if the government says this is a matter of national security, the courts have always been very much letting the Department of State, which controls the embassies and consulates around the world, the National Visa Center in the US. The courts, if they had gotten, lawsuits on this, the courts are always very much protecting the idea of national security and let the Department of State make its own decisions. And they are the ones with the most information. So to be honest with you, this could have been worse. This could have been a lot worse. And I don't like the way it is. But what I told people is when I first heard the news, right? Like this is something anyone will understand. My level of concern or worry, if 0 is none and 10 is everything is in trouble and going bad, my level of worry was like maybe an 8, and then when we saw it's on economic reasons, my level of worry went down to like a 2. This is a totally different sort of thing. So, I think that we know the countries it applies to. It's not everyone, but of course it's a lot of our countries where people are from. Second citizenships get you around it. There's lots of things we can do to try to keep our cases moving, and we will. But I don't want to be too overly worried. This is not a cancellation of the EB-3 visa. That's something that is set by Congress. It cannot be changed by the president or the administration that's in power. There's a certain number every year of visas. They count it the same every year. They do the same processes. And one of the rules in US government is there are some rules that have to be set by our Congress, the government of 100 senators, 435 people in what are called the House of Representatives. And those rules can only be changed by Congress for the most part. Then other rules are allowed to be set by the president, and they can be changed by the next president. But the EB-3 visa program itself is a Congress rule, and it can only be changed by Congress, and there's no appetite or wanting in Congress to change it. So that is what we're, operating under. We do have the restriction to the 75 countries. We do not like it. That is something the president can do, in general. But we think in this situation, the way the lawsuits are going is putting this rule in place and applying it to employment cases is, what I would say, it's a solution in search of a problem. There's no problem that's being solved by it because all these people have offers of employment that are being confirmed. Our EB-3 program is not at risk. We do have this restriction. We do not like it, but we think we're going to be able to get around it. And there may even be lawsuits that succeed in getting it totally erased, at least as it concerns our cases. So I know there's a lot of things that have been happening recently. This, of course, is one of them. This is the biggest one. This is getting the most headlines. Something else we're seeing is I-140s, and I'm just kind of going down a list of things we want to discuss. We can take questions at the end. So if you have them, save them, and we'll do that. But, we're seeing I-140s being approved quite quickly now, sometimes 2 weeks, 3 weeks, 4 weeks, 5 weeks, with regular processing cases. And, we like approvals. We like approvals at any stage.
Yes.
I-140 approval is really, really a critical moment. We do not ever think sponsors, employers will stop the program, but sometimes things change in economics. Sometimes things change and businesses close. Sometimes needs change or people sell things or, anything can happen in the future. And this is a long process. Mm-hmm. The I-140 approval is critical because that means your priority date, even if the worst thing happens and the employer goes out of business and can no longer take cases, it means your priority date can still be used. You do not go back to the beginning of the whole process. Even if we need to do a new labor certification, a new 9089 and a new I-140, that'll be very frustrating. It'll be very frustrating for all of us. None of us want that. But the I-140 approval locks the priority date. So, the I-140 approval is a critical moment in this process. Getting it approved faster, getting it approved in, 8 weeks instead of 8 months is a huge benefit for peace of mind mentally. It's the worst case situation away, which would be needing to start again and losing the priority date. And so it's a very, very good thing. The question is why, though, this is happening. USCIS has not announced this. Sometime around US Thanksgiving, in the end of November, we started noticing that the cases were being approved much, much faster. The new ones we were just filing then, and the new ones we were filing in December, getting approved very, very fast. And the earlier ones were really not being touched yet. But then a couple months later, they started getting to those faster and faster, and they were doing, our August cases in 5 months instead of, 10 or 9, right? And, we're asking why. And I think the reason is because USCIS, in reviewing these cases, when they get them, they get scanned at the mailroom, and then we have to file them on paper, but then they get scanned, and that becomes the file. USCIS, I think, as an early stage screening or review tool, started using some sort of AI tools that, look in the I-140, they look in the memo, and then they look in the exhibits, and they check information, and then they pull it all out and put it in front of the officer. And then it gives the officer, faster information. And I have no proof of this. They have not announced it. We do not know it for certain, but it's the only explanation that really makes any sense. Because the other one is they stop processing I-130s and I-129s, and everyone is doing our cases because we're the best and we're everybody's favorite. And that's not realistic. It's a technology-based reason in one way or another. I think it's AI tools pulling the things off.
Mm-hmm.
Initially, this resulted in a higher percentage of requests for evidence because I think it was set to issue them in a certain percentage of cases. And we usually do pretty good work in the beginning, and we have a very low number of those. And it got higher. It went from like 4% to like 12 or 15%. And it's a little frustrating. It's more things for us to ask employers for. It's more things for my office to do and manage, but it's worth it because we're going faster.
Mm-hmm.
And we're locking people's, priority dates forever, no matter what happens. So again, we look at it, from a positive spin and try to be as happy as we can. And I think this overall is very good. We figured out ways to, change some responses in the I-140 and make things like, rather than saying, look at the memo or look at Exhibit 2, we put the numbers in the different places, and we figured ways to get the RFE number down a little bit from what we were seeing earlier. I think USCIS may have changed the prompts as well. I don't know how much anyone really cares about the details of this because you just want your cases approved. But I think it's a technology tool that's resulting in them looking at cases faster. And this is very, very good for us. We're very, very happy. So that's the explanation for that. We're going to do a couple things about visa processing, family member eligibility, Child Status Protection Act calculations, and so on. Again, if you got questions to follow up on any of these, please ask us either at the end or privately. I think what we're going to try to do, I've done enough of these meetings in my career where I think we can talk about enough general information to give, to answer 95% of your questions, without you asking them. But if anything different comes up or personal, just let us know. Mm-hmm. But we're going to do a bunch of visa processing questions right now and a couple adjustment of status questions. Can a person do an interview in a third country where they reside, but it's not their birthplace or citizenship country? The answer is yes. However, the administration put in a rule last September, and I know it's September because we were away with another family, my son's best friend and his family, and the announcement got made on a Friday night, and everybody got worried, and I had to wake up at 4:30 in the morning and start sending emails off to everybody, and I annoyed my wife and so on, that I was doing that on the weekend, but understandably. But anyway, yes, wherever you live, you can do the interview there, as long as you can prove residency. It does not need to be permanent residency. It can be a work permit. You just have to prove legal status in that country and that you're there. We need to prove that to the National Visa Center. There are some countries that do not really enforce immigration rules. They do not care about overstays and things like that. We are going to have a problem if someone does not have status trying to get their interview scheduled there, because we're not going to have the documents to show it. Mm-hmm. And so we'll take those on a case-by-case basis. To me, it seems like maybe mainly Israel, where we have some caregivers and so on. But if we can prove the residency in the third country in any way, we can do the interview there. So there's lots of people from Thailand, Philippines in Dubai, for example, right? Like there's 400,000 Filipinos in Dubai or something, or in the Emirates, I don't know, but it is a huge number. You'll have your work permit or your entry visa. We'll be able to prove it. We'll be able to move the interview there. Certainly Abu Dhabi is not the best place to do an immigrant visa interview, but better than Manila, you know? And so just because the queue is shorter, not because it's different, you know, but we'll take it as it comes. We'll do what we need to do. We'll upload the documents for you that we need to upload. We'll communicate to you when that's necessary, and everything will be fine. Next question is just about, to be considered an eligible dependent, must someone be under the age of 21 the time the priority date becomes current? Generally, yes, there's a small amount of time subtracted from that. It's the time the I-140 is pending. As we discussed, many of the newer cases, that's only going to be 4 or 8 weeks. Some of the older cases, it might be, you know, 10 or 12 or 14 months. Say there was an RFE and took longer to respond to. That time gets deducted from the child's age. If you look on Google for something called the Child Status Protection Act, or CSPA, you just put in US CSPA calculator. You can put your priority date, I-140 date of filing, I-140 approval, and the child's birthday. We'll tell you what the child's CSPA age is today. We'll tell you what it is at a future date. It's just, I mean, look, it's a simple computer program. You know, any of us probably could have written it in 2 hours, but there are calculators online to check your child's age and eligibility, but generally, yes, it's 21 or under, or it's under 21, not having yet turned age 21. And it's a clear line. 20 years and 360 days is okay. 21 years and 0 days on the birthday is not. You know, is the line. That's how a lot of things in immigration are, right? Like the US government sets it to be as clear as possible, as fair as possible, as transparent as possible. And so it can apply to everyone with as few questions or disputes as possible. And so this is another one of those things. And frankly, I like those because I like to know yes or no, and maybe is frustrating. And I think that's how like most people are with most things in life. You know, and so I think that's, you know, about the age and how do we calculate the Child Status Protection Act. But honestly, these online calculators, my office uses them too. We use them probably every week. Someone's using them in one way or another. If something gets done wrong or calculated wrong by the Department of State, let us know. We know how to like fight these if we think we're right. Sometimes people calculate things themselves and they're not correct, and we have to say, I'm sorry, this is not how it works. But, you know, sometimes the Department of State is not right about these. So, yeah, so that's the calculation. Next question is, I think about someone who is going to be filing for an adjustment of status, and should they fill out an I-131 form if they do not plan to leave the US? So when we file for an adjustment of status, when someone's got an approved I-140 and their priority date becomes current, or they have an older priority date they can use or whatever, and they're inside the US and they're in valid non-immigrant status, student, maybe visitor, H-2B, whatever it might be, we file for what's called an adjustment of status. We file 3 applications, the one for the green card, which is called I-485. We file one for employment authorization, I-765, and one for travel permission. And the reason we file those second 2 is they usually get approved first, more quickly than the green card does. The green card's a background check. It's more work, more things for them to look into. They check records in other countries. They check the US records and so on. And so they want to give people employment authorization and the ability to travel before that's approved. Pretty much everyone wants to get the work authorization. There's an additional government fee for that of $265. Not everyone says, I think I'm going to travel outside the US and file the I-131. The filing fee on that, which is $630 a person, right? And so if it's like for family members, what does that come? $19.20. Like you save like $2,000. No one's required to file for the employment authorization. No one's required to file for the travel authorization. It's your choice. We will do whatever you tell us. To me, I think in the context of the costs of all of these programs and everything everyone's paying going along, how much you've been waiting, like, I hate to say this, but like, you know, I'm 44 years old. My parents are in their 70s. Like, a lot of you are the same or similar. My dad's in good enough health, but not the best. My mom, I think, is going to live forever. But like, to me, the travel permission is an insurance policy. And so if it were me and the $2,000 was not going to make or break what my family was doing in the next year, I would file for the travel permission just to make sure we have it. Things can always come up. You know, parents can be sick. It could be something happier. Your brother could be having a baby in Thailand or whatever that you want to see. And you have 2 weeks off from work or school or whatever, and you're going to go visit. So there's nothing forcing you to do it. We're not going to tell you you need to do this at all. But to me, it seems like better to have that and not need it than to not have it and want it. If you do not apply for it, there are ways we can get an appointment at the local USCIS office, but that will involve filing it later. You can't get it expedited without it being filed, right? And so they can't approve a case that has not been filed. So it's going to involve filing it at some time if you wind up needing it. And realistically, to even get the expedite and get it approved is probably like a 4 to 6 weeks process, because I've had to do this before. And emergencies generally do not come with 4 to 6 weeks of notice, you know? And so that's kind of how I view that generally. Then 2 more little questions are, if a client arrived 5 years ago and gave birth to a child in the US, but is currently residing elsewhere, is she eligible for an EB-3 visa? Yes, you know, yesterday I spoke to someone about their case who has a US citizen child, and they're coming back for some temporary work and so on in a different visa type and everything. She's got a US citizen child. She's going through the EB-3 process. She's got it approved 9089 and I-140 and just waiting, you know, to get the final stages done. So yeah, there's nothing stopping that. And then last one was someone who held F1 status previously, is applying, but for a marriage-based green card, but it's not going, the marriage will not continue. Can she apply EB-3 visa? She no longer has F1 status. I mean, definitely, yes, the EB-3 visa is possible, but the issue is going to be residency in the US and valid immigration status. If they withdraw the I-485 based on the marriage or something, then the person loses the immigration status. They would need to reinstate F1 status or visitor status. Visitor status will not be able to be kept long enough to do an adjustment of status, so it may require departing the US and changing this from in your mind adjustment of status case to a consular case, because you need an immigration status in the US that's valid when you're filing the I-485.
Right.
So that was the list of questions that were sent in ahead of time. But like I said, anything you've got, I know we're kind of reaching what we said was the end of the time, but I'm happy to, you know, spend another 10 minutes or whatever doing any questions people have. Now, if anything's come up, you can put them in the chat or the comment. You know, anyone can ask them, and we'll answer whatever we can.
Yes, I do have few questions. Could you please give us an example of public charge that's
Sure.
The Department of the State have mentioned?
Yeah.
Because of the suspension.
The assessment in the very first thing we talked about when I said it was economic reasons is the government has this thing they consider a concept called public charge. Like charge just means cost, essentially. Like originally they called credit cards charge cards, right? Like I know credit cards are more popular in the US and everything than elsewhere, but originally, like when I was growing up, my dad had clothing stores and things like that, and they called them charge cards, and you had a little machine that you went like that and it printed it, right? And it made a little paper with copies and you sent it into American Express or whatever to Visa. Charge just means like a cost or money, and public, of course, means when the government says public, they mean government, right? And so what the government wants to avoid is people becoming a cost, a charge to the public, to the government. And so, you know, usually the way for immigration purposes, the easiest way to do this, and I can go into the details of this as much as we want to, but I think it's not a good use, right? Like at a certain point, there's a good amount of time to spend on something, and after that, you accomplish very, very little, even if you spend more time. A very simple thing to keep in your mind about, do I have a public charge issue, you know, from the past or anything, when I was in the US as a student or a visitor or H-2B, whatever. Very simple. And it's this: was there a direct payment of cash or the equivalent of cash from the government to you? And if the answer is yes, there's a very good chance we have a public charge concern. And if the answer is no, and it's almost always no, if the answer is no, we probably do not have an issue. This will be correct in probably 98% or more of questions. This will answer almost every question a person has, you know. And so I'll give this example. An example of something that would be considered a public charge is if you apply to the government and you say, I have no money, I have a 5-year-old kid, we need money to buy groceries. They will send a card to you and it will be loaded with some money every month. And when you go to the grocery store, and it might be called SNAP, it might be called EB-3, there's different programs and everything. And you go to the grocery store and you put that card in the machine to pay the same way I, you know, tap mine on the thing and pay for it, you know, with my family's money. And then the government sends that cash to the supermarket. That would be considered a public charge issue because it's a direct cash or cash equivalent payment from the government, you know, on your behalf to someone else. What is not a public charge is buying medical insurance through one of the exchanges where you go online and they do a pool of, you know, thousands of people and everyone pays the same amount for insurance. And, you know, the statistics are what they say. And maybe someone who is 60 years old is paying less than they really should. And maybe someone who's 25 years old is paying a little more than they should, but they each pay the same $100 whatever a month. That's not a public charge. There is no direct cash payment there. That is a private transaction. It is private insurance. And so that does not involve a direct cash payment anywhere along the lines. That system is set up by the government's like rules and regulations, and then the insurance companies kind of deal with it internally with how they set up the exchanges and how they price the insurance. So again, comes back, 98% or more of questions will be solved with, is there a direct cash payment somewhere along the line? The answer is yes, we need to think public charge. If the answer is no, almost certainly there is no public charge issue or consideration there.
Yeah, but I mean, for if the student here and then she's sick and she go to the hospital and they have a bill and then she said that she doesn't have money to pay, and then I think the
there can be, I understand, there can be old medical costs and those would not impact the EB-3 process. They may still exist. They may get sent to a collection agency. They may be held on the books of the hospital. They may be due in the future, but that is not public charge, right? Because like the hospital is private. The hospital is not the government. The hospital is its own business, and anything they say they are owed, it may still be owed, and it may be an issue on things like credit or whatever, but it's not a public charge consideration because the government is not involved in that. The critical piece of this is there has to be a direct payment, and it has to be from the U.S. government.
Oh, that's good to know. Yeah.
How could they find out if, for example, if I came here maybe 10 years ago, I used something and I totally forgot whatever I have done, and would those be a record, or how could the Department of State find out all those charges? It will be a record all this time in the system, or how could they know that we have?
Yeah, I mean, I do not think the government really wants to go into every fact or detail in someone's economic history.
Yes.
If there's a private medical debt, I think that most likely will not ever come up because it's not really one of the factors that ever gets considered. With that being said, in every case, we have to assume the US government knows everything we have ever done, probably in our lives, certainly in the US, certainly in the last 5 or 10 years. The United States government has access to more information than any organization that has ever existed in the history of the world, by far. The US government knows everything. We are not going to be able to hide anything. We are not going to be able to change anything that exists. We are not going to be able to avoid them knowing something. We have to assume in 100% of cases that anything the US government ever might want to know, they already know. We are never going to be able to assume that we will, we have a problem and it will be okay because they will not find out. The days for that, if they did not end, 15 or 20 years ago, certainly they ended 10 years ago. But the amount of information through technology that the US government has access to, there are multi-billion-dollar, $100 billion businesses whose job is to just find information and basically give it to the US government so they can know everything about everyone, right? Privacy is a concept that no longer exists. And that may not be good, and it may not be something that's pleasant to hear, but it's the reality, right? So, but no, something really old, I think if it exists, that is, we just have to assume they know. But things like medical debts or things that are on the books, those do not create public charge issues or concerns or considerations.
Okay.
That's good to know.
Would you give any recommendation what they're supposed to, I don't know, just for example, all the EB-3 unskilled applicants that will be coming here to be prepared, or any recommendation or anything in your points of view before they came here? Just ask for a recommendation. Would you have anything to say to the applicants who apply for EB-3 with us before they came here? What should they be prepared and get ready, or
Yeah, I mean, I would say, usually it's a good idea in the beginning of this process to do as much as you can. Organize all the things you're going to need, and they probably will not change. Your birth certificate's not going to change. Your marriage certificate's not going to change. Passports do expire, but they're also good for 10 years, right? So that's probably not going to change. So I mean, I think do as much as you can. What I do not want anyone doing at the beginning of the process is getting police certificates. Maybe they're in Thailand or Philippines now or whatever it is, and they used to live in Dubai and they want to get a police certificate. Those are not valid forever. And so we do not want to get them too early because we're just going to have to do it again and we will have wasted our time. And money, but usually they're not very expensive. But sometimes they're difficult to get, or you need to send someone to personally go on your behalf and sign a power of attorney and anything. It really depends. It's specific to the location where they're being ordered. But everything other than a police certificate, I think it's a good idea. Now, look, things change. People get married, we add a spouse. People have a kid, we add a kid. People get divorced, sadly, we take the one who no longer qualifies off. We can do all that later, very easy. You get a new passport, we'll add the new passport. But yeah, I mean, I think at the beginning of the process, it's just a good idea. Like, do everything you can, do everything you need, make sure everything is there. If you find a problem, it may not stop the application from starting, but at least you know it. There may be something wrong on your birth certificate you need to correct. You may have what they call a short form birth certificate, but we need a long form one, because the parents aren't listed, something like that. Things can always come up. So it's good to do this at the beginning, not the end when we need it and we want to be going faster and we want to be getting you towards the interview as quickly as we possibly can. So I think good idea to do a little bit of work at the beginning, but not everything, not the police certificate. And anything that does change in the future, we can do it.
Thank you.
Yeah, thank you for today. Yeah, I think we good today.
Look at the time, right? We went by so fast.
All right. Thank you, everyone, for joining. Nice to be with you. Nice to see some of you.
Yeah. Thank you so much. And if we have some question, we will send it to your office. Yeah. And
very good. Thank you. We appreciate it. And we look forward to getting this process done for everyone and having a good, successful journey and getting you the green cards that are at the centerpiece of all this, having you join the employers, doing a great job for them. They need your help. They wanted you here yesterday. And they wish this process was going faster too. So we look forward to bringing it to a successful conclusion for you. Thank you for your trust in us. And, we take that very seriously. And hopefully for many of you, we've done a great job already. And for those of you who we haven't, we look forward to doing a great job for you in the future.
Once again,
great. Thanks everybody. Bye-bye.
Thank you so much, Paul, to be here with us today. And for the people at home or the viewer, if you have any further question, you can reach out to us and we will send a question to Attorney Paul.
Okay, very good.
Thank you.
All right, thank you so much.
Hope you have a good weekend then.
You too. All right. Bye-bye.
Thank you. ขอบคุณค่ะ
โอเค
เวลาไปรวดเร็วมาก
วันนี้ก็
รู้เยอะๆแน่นๆเลย
ได้ความรู้เยอะเลยแล้วก็เป็นเนื้อหาสาระที่ดีมากเพราะหลายๆคนก็ติดตามเรื่องเกี่ยวกับนโยบายที่เปลี่ยนแปลงมากันตั้งแต่ต้นปีนะคะวันนี้ก็เคลียร์เลยนะคะว่าวีซ่า EB-3 วีซ่าไม่ได้ถูกแคนเซิลไปไหนแน่นอนนะคะแต่อันนี้ก็เพราะว่านโยบายตัวนี้ก็จะเป็นอย่างที่พอบอกว่าตัวนี้เราได้ใบเหมือนกับเราทำงานเนาะเราเข้ามาทำงานตรงนี้นะคะดังนั้นเนี่ยวีซ่าตัวนี้ยังคงอยู่นะคะก็
แล้วก็เพิ่มเติมก็คืออย่างที่เราทราบกระบวนการต่างๆก็ยังดำเนินการได้ปกตินะคะที่เราจะไฟล์ LC กับ Department of Labor ไฟล์ I-140 กับทาง USCIS เพราะว่า2ขั้นตอนนี้เป็นขั้นตอนที่ทางสปอนเซอร์จะเป็นคนดำเนินการให้เราเพราะฉะนั้นใครที่ตัดสินใจก็ควรที่จะเริ่มเลยเพื่อที่จะ log in your priority date
yes
นะคะจะได้แบบว่าเริ่มแล้วก็เข้าคิวในการที่จะได้รับหรือจะก็คือถึงแม้ว่าจะมีการระงับไปตรงนั้นแต่ว่าทางสถานทูตเองก็ยังมีการที่จะเรียกสัมภาษณ์ให้สัมภาษณ์หรือว่านัดโดยปกตินะคะขั้นตอนที่แตกต่างไปจากเดิมก็คือแค่ยังไม่ได้ออกตัววีซ่าให้เราแค่นั้นเองนะคะแล้วก็หลายคน
ตกใจสอบถามว่าทำไมมันI-140 approve เร็วจังนะคะ approve เร็วก็ดีแล้วนะคะอันนี้ก็เป็นตัว เราจะใช้ priority date ตัวนั้นนะคะ โดยที่ถ้าสมมติว่ามีการงานถูก cancel ขึ้นมาเนี่ยเราไม่จำเป็นจะต้องย้อนกลับไปเริ่มต้นนะคะ แล้วตอนนี้เรามีงานอะไรเหลืออยู่บ้างคะนีน่า
ยัง2 งานของที่ทาง MCC นะคะกับLawrence Bus Service นะคะทำความสะอาดแล้วก็ดีเทลรถนะคะ17 เหรียญต่อชั่วโมงอยู่ที่เบรนท์มินนิโซตาค่ะไม่มีอินเทอร์วิวแล้วก็อีกงานหนึ่งที่เราคุยกันประจำ Stotter Trailer ซึ่งไปเยี่ยมโรงงาน
ได้แล้วก็ไปที่นี่มาแล้วด้วยที่นี่
เป็น
อยู่ที่
สปอนเซอร์ที่มีความมั่นคงสูงมีจำนวนพนักงานมากมายแน่นอนว่าในระยะยาวในการพิจารณาสปอนเซอร์นี่เป็นสิ่งสำคัญนะคะสปอนเซอร์ที่มีความมั่นคงแน่นอนว่า5 ปี 10 ปีข้างหน้าเขาก็จะยังอยู่แล้วก็สปอนเซอร์เราแล้วก็ยังต้องการคนงานอยู่ตลอดอันนี้คือเป็นหลักพิจารณาหลักๆที่ทางพวกเราค่อนข้างที่จะเน้น
ใช่ค่ะแล้วเราไม่มีค่ะเราไปโรงงานเขาเราก็เห็นแล้วว่าเขากำลังขยายงานนะคะขยายบริษัทไปเรื่อยๆนะคะดังนั้นเนี่ยเขาอยู่อีกนานที่ทำให้โปรเซสเราสมูทมากที่สุดนะคะเพราะว่าโปรเซสเราก็คือประมาณ 4-5 ปีดังนั้นน่ะหาสปอนเซอร์ที่มีความมั่นคงอันนี้จะดีกับเคสของคุณมากที่สุดนะคะ
ก็รีแคปให้อีกเพิ่มเติมอีกนิดนึงก็คือเดี๋ยวเราจะแปะลิงก์นะคะในการที่บอกว่าจะคำนวณ CSPA อายุของเด็ก calculation ให้นะคะเดี๋ยวเราจะแปะลิงก์ไปทางสื่อต่างๆของทางเราให้ที่บอกว่าอยากจะคำนวณอายุของเด็กในวันที่อะไรเงี้ยจะมีผลพิจารณาอะไรยังไงเนี่ยค่ะก็ประมาณนั้นท้ายที่สุดก็อย่าลืมฝากติดตามไลค์แชร์นะคะทาง Facebook Instagram YouTube ถ้ามีคำถามเพิ่มเติมที่จะส่งให้ถึงทางคุณทนายพอลก็ไลน์ OA เข้ามาสอบถามเราได้โดยตรงเราจะได้ส่งคำถามต่อให้นะคะ
ทุกคำถามนี่เราจะส่งให้กับทางทนายโดยตรงอยู่แล้วนะคะแล้วเราก็แต่ว่าตรงนี้ต้องขอเวลานิดนึงนะคะถ้าสมมุติว่าส่งคำถามที่จะต้องส่งให้ทนายเนี่ยเราอาจจะต้องคอยสักประมาณอาทิตย์2 อาทิตย์นะคะแล้วเราก็จะส่งคำตอบให้นะคะโอเคค่ะวันนี้ก็ขอบคุณมากๆนะคะที่ติดตามรายการเรานะคะก็เจอกันใหม่คราวหน้านะคะสวัสดีค่ะGood nightค่ะสวัสดีค่ะ